There's been a lot of discussion recently about the common use test and why it's so helpful to the right to keep and bear arms in the United States. A lot of confusion out there. I'm going to clarify it for you right here and right now. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the United States Supreme Court Bar, proud American gun owner, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. And again, we're really working hard to try to get to 100,000 subscribers. It'll make a big difference with the social media algorithms, helping to get our Pro 2A message out. All right, so common use test. Here's why it's so important. So let's step back. I'm going to break this down. In 2008, the United States Supreme Court heard a case called Heller versus the District of Columbia. The District of Columbia had banned handguns in D.C., including handguns in the home. That law was challenged. In Heller versus the District of Columbia, the Supreme Court found that the gun ban in the District of Columbia, the handgun ban, was unconstitutional under the Second Amendment. It found that the Second Amendment's right to keep and bear arms did several things, one of which is it protected the private right, the individual right to have guns, which means, to keep means to have, and the right to carry guns, which is the right to bear means to carry. So the Supreme Court found that. It also says that the main purpose of the Second Amendment is to protect Americans against all forms of tyranny, and that they're allowed to have guns for all lawful purposes. Not just self-defense, but that's a main part of it, but not just self-defense, for all lawful purposes. And they also said that you have a right to a loaded gun unlocked because there was a trigger lock requirement in D.C. that was struck down that says that if you have a gun in your home, you have to lock it up. And the Supreme Court says, no, that's not allowed, because if you lock the gun up, you have a hammer, right? You don't have a gun anymore if you lock it up. So you can't force Americans to lock up their guns, because then the purpose of being able to use a firearm in self-defense, meaning to anticipate a confrontation where you have to act quickly in self-defense using firearms under the Second Amendment, the Supreme Court says you can't lock it up. So the trigger lock requirement in D.C. was struck down as unconstitutional. That is a often kind of ignored fact about the Heller decision, but that is also the case. Okay, so that was Heller in 2008. Now, here's the key. When the Supreme Court, and I want to be very clear about this, I don't want there to be any confusion. The common use test that says that weapons, arms that are commonly used by Americans for lawful purposes, that test, that standard, is a pro-gun standard. It is good for the Second Amendment. It is good for gun owners. It prevents basically all firearms in the United States, certainly all the ones that are owned now, set the machine gun issue aside, but all other guns, other than machine guns, which is a separate issue, are protected, cannot be banned, including magazines, as I see it, as I think the law will develop. And let me explain why this is so important and how the Supreme Court got here and why this is the law. So in the Heller case, that again found that loaded handguns unlocked in the home are protected arms, the Supreme Court did a series of things. And one of the things they talked about is, how do we figure out what arms are protected? And they said that all bearable arms are protected under the definition of the word arms that's found in the right of the people to keep and bear arms, shall not be infringed. So what they said was, and they looked at the history here, and remember, the Supreme Court did the history of defining the words in the text of the Second Amendment. So now lower courts, I'm digressing a little bit here, but lower courts today are not permitted. They're not permitted to revisit these definitions and interpretations of the Second Amendment's words. So when you see the words that the plain text of the Second Amendment is step one, that is not an open invitation for lower courts, often referred to as inferior courts under the Article 3 of the Constitution, inferior to the Supreme Court. That is not an open invitation for lower courts to start to make crap up, which is what we've been seeing across the country. That's not allowed. Because when the Supreme Court talks about the plain text of the Second Amendment protects everything in that text, they don't say you get to reinvent the definition of what those words mean. No, it says that you have to take the plain text of the Second Amendment as given to you and is interpreted by, as defined by, the words found in the Supreme Court's precedents that function really as a dictionary or thesaurus, if you will, of the text of the Second Amendment. The Supreme Court has done all the heavy lifting of defining these words and what they mean. Now it's just up to the lower courts to apply them textually. It should not be that hard, but the lower courts, some are resisting because they don't like guns and they don't like the outcome that NYSERDA versus Bruin is requiring them to find. Okay, so let's step back though. In Heller, and this is what's very important about the common use test, when the Supreme Court was defining what arms are protected, they looked historically to see what arms could be banned. Now, as you know, the Second Amendment does not create rights. It guarantees or codifies pre-existing rights. The Supreme Court specifically said that, by the way. This is not my interpretation. It's not your gun club's interpretation. No, the Supreme Court literally said that the Second Amendment's right to keep and bear arms, codifies a pre-existing right. It memorializes a right that already existed. But then what the Supreme Court did is they said, look, we obviously need to interpret these different words. So we looked to the definition of word, and they tried to figure out what arms meant. And they went out and they looked at dictionaries and history, like the definition of arms by Samuel Johnson, a famous lexicographer. Again, lexicography is the study of dictionaries or the creation of dictionaries. So Samuel Johnson was a famous British lexicographer, and he defined arms as basically anything you can use offensively or defensively. So a very broad definition of arms. So after that, and again, we've talked about this before, the way it works is the text give you your rights. The text of the Second Amendment guarantees your rights initially. That's what your rights are. However, the Supreme Court says that once the text covers an activity, it's presumptively protected under the text of the Second Amendment, as that text is interpreted and defined by the U.S. Supreme Court's precedents of Heller, Catano, Miller, Bruin, etc. Okay, now, the Supreme Court then goes on to say, however, if the government can show, and the government bears the burden to prove this, if the government can show through long-standing traditions in history that some regulation involving firearms has existed since our founding in the late 1700s, then that long-standing history can be used to limit what the text giveth. And I keep saying, and this is my language, you can take it from me, I don't care, it's about winning, as far as I'm concerned, about getting it right, involving the Second Amendment. The way to think about it conceptually is that the text of the Second Amendment giveth our rights, and that the historical analogs from the 18th century, to the extent they exist, can potentially taketh some of our rights away. That's when you hear the text and history test. The way that's supposed to work is the text articulates the scope of the Second Amendment, but then that scope can be shrunk to some degree by historical analogs going back to the founding, and there are very few of them, but there are some. For example, you're not allowed to use a firearm and misuse a firearm to, for example, commit a robbery, because you weren't allowed to use a gun to commit a robbery in the 18th century, so you can't, and that's been the law since through today, right? So you can't use a gun to commit a robbery today, because going back to the founding fathers, you couldn't misuse a gun to commit a robbery then. So that's an example of a long-standing restriction on your use of firearms that would be upheld today as constitutional. The Second Amendment doesn't guarantee you a right to use a gun to commit a robbery because of the long-standing tradition in American life against using guns or misusing guns to commit robberies. Okay? So again, the text giveth, but the history through historical analogs of the 18th century has the possibility of taking some of those rights away. Now, with that said, with that idea in mind, text giveth, history taketh away our rights. The Supreme Court then looked in Heller to say, is there any history in the 18th century that the founding fathers thought a gun ban of some sort might be okay? And they did find one example of this, where they cite to William Blackstone, an English commentator, a very famous English lawyer, wrote a very famous book called Blackstone's Commentaries, used robustly in the United States in the early part of our American life. And they found one exception, that there were bans on carrying, quote, dangerous and unusual weapons. Okay, now I want you to pause. Now, two things to know about this. The anti-gunners today try to argue that the test for and I'm going to tell you why this is all good for us. There's nothing bad about what I'm saying, okay? I'm going to tell you why there's nothing bad. Do not worry. This is not bad for us. I'm going to tell you why, okay? The anti-gunners argue that the test to ban guns is not dangerous and unusual, which is conjunctive together. They argue it's not dangerous and unusual, that the real test is they can ban firearms in American life if a weapon is dangerous or, hear what I just said, disjunctive, not conjunctive, disjunctive, dangerous or unusual. Now, the anti-gunners are 1,000% wrong. I repeat, 1,000% wrong with making that argument that it's dangerous or unusual. What they try to do is to say that if you go back to Blackstone's commentary, I know this is geeky, but I want you to understand this. They argue that if you go back to the English commentaries, William Blackstone's commentaries, which are English, he talks about dangerous or unusual weapons. However, when the United States Supreme Court took the Blackstone and discussed it, the Supreme Court of the United States, which is the binding law, they can use William Blackstone's commentaries to guide them about American law as appropriate, but they don't wholesale grab it because it's English law. We can use English law to help us interpret American law sometimes, but we don't just wholesale pick up English law and bring it to the United States and say it's our law, because they're not the same. So the Supreme Court said that the standard is dangerous and unusual, but the anti-gunners argue or, and they try to bring over yet again English law, but the Supreme Court rejected that interpretation and said the standard is you can ban guns in the United States if they're dangerous and unusual. So just be aware if you see this disjunctive, conjunctive argument, where that comes from, and the right answer is the only way a firearm can be banned in the United States in any respect is it has to be dangerous and unusual. Okay, now, the burden is on the government to show historically that a particular weapon is dangerous and unusual. Now, as to the common use test, why is the common use test or the common possession test so good for America's rights to keep and bear arms? Step back for a second. Just think about this comment. I know it's a legal thing, but it's actually not. It's really common sense. And everyone watching this video can totally get it, even though I know this is like legal history and legal mumbo jumbo in the Supreme Court. Very simple. If the government can only ban weapons or arms that are dangerous and unusual, what type of arms am I not allowed to ban? What type of arms is the government not allowed to ban? Well, if an arm is commonly possessed, is commonly used, by definition, what is it not? Well, if it's commonly possessed or commonly used, by definition, it cannot possibly be, in any universe, unusual. You see? The government bears the burden to show that an arm is dangerous and unusual to ban it. Then they bear that burden. So if you come forward and demonstrate, and you don't even have to demonstrate it because really the burden's on the government, but if you show that semi-automatic handguns are commonly owned by millions of Americans, which was really Heller and Catano, they're commonly used. Guess what they are? They're not unusual. And because semi-automatic handguns are not unusual because they're commonly owned, they cannot possibly be dangerous and unusual, which means the government attempt to ban, let's say, semi-automatic pistols, what they tried to do in Heller, is not allowed under the Second Amendment. Likewise, if the government, if they're trying to ban certain types of semi-automatic rifles in the United States, of which there are tens of millions, for example, of AR platform semi-automatic rifles, well, we can agree that something that's millions, never mind tens of millions, that are owned out there by Americans is commonly owned, commonly possessed. So if a semi-automatic rifle, like an AR platform firearm or an AK platform semi-automatic rifle, if those are commonly possessed, and we know they are, because remember in 2016, the Supreme Court in Caetano versus Massachusetts said that stun guns were commonly possessed. And how many stun guns were there in the United States in 2016 when the Supreme Court found that? 200,000. 200,000 stun guns were commonly possessed, commonly owned by American private citizens for purposes of self-defense. And that was considered commonly possessed or commonly used for lawful purposes. So we know that if AR-15s and AK-47 semi-automatic rifles are owned, tens of millions of them, which we know there are millions, and actually tens of millions of them. We know from the National Shooting Sports Foundation data alone, there's over 20 million of these. And then you look at like Georgetown professor William English's work, he has it upwards of 40 million. Whatever it is, it's tens of millions, far more than 200,000 we talk about it in stun guns with Caetano. So it doesn't even matter what the answer is because it's clearly commonly possessed, commonly owned. So by definition, because AR-15s and AK-style semi-automatic rifles are commonly owned and commonly possessed, they cannot possibly be dangerous and unusual under the Supreme Court standard for banning guns, which means that any arm, whether it be semi-automatic pistols, revolvers, or semi-automatic rifles, are commonly owned, and therefore they cannot be dangerous and unusual, which means they cannot be banned in any respect, shape, form. Likewise, magazines, standard capacity magazines that hold more than 10 rounds. We're going to do a lot of talking about this because it's a little bit more complicated. It's not more complicated. It's just more complicated for judges that don't understand firearms technology. If they don't fire a gun, they don't know any of this stuff. You have to teach it to them, and they can easily be duped if they don't get taught right. So again, we know from precedent that you can't have guns that work for self-defense without ammunition, which would be bullets. And we know that the Supreme Court has said that we get commonly owned. By the way, the Supreme Court says we're not bound by what the 18th century arms are. We get modern day firearms. So if today Americans commonly select or own, commonly use, semi-automatic rifles, semi-automatic pistols with magazines, with ammunition that goes with them, those are commonly owned, and therefore they can't be banned because they're commonly owned. And therefore, by definition, the government cannot ban them because they're not dangerous and unusual, because the government cannot meet the and unusual standard because these weapons are commonly owned. See? That's why this is so good for us. Set aside the machine gun issue, which we'll do an independent video on machine guns because that has some twists and turns to it that we can talk about. But right now, the most important thing we can do, as I see it, is to get a Supreme Court decision that says that semi-automatic rifles are protected arms. They clearly are, but it would be nice to have a Supreme Court decision that robustly, unequivocally holds that, and also dealing with magazines. And the reason why magazines are clearly protected arms is because, again, semi-automatic pistols are protected arms. We know that from Heller. We know that from the language of Caetano, which talks about semi-automatic pistols specifically. And by definition, semi-automatic pistols require magazines. Once they require magazines with bullets, right? Because if you don't have a magazine that can feed ammunition into the gun, you have a single-shot firearm, which is clearly not the key to the Second Amendment, because the Supreme Court has already said that firearms commonly possessed, commonly used in the 21st century, in the 20th century, 21st century are protected arms, and we need magazines and bullets to, effectuate our right to self-defense and other lawful purposes. Remember, it's not just the right to self-defense, it's the right for all lawful purposes to have these firearms. And if Americans have selected these firearms, these semi-automatic, pistols, and semi-automatic rifles for self-defense or any lawful purpose, then they have so done it. And since you need magazines, otherwise you really have single-shot firearms, which the Supreme Court says that's not enough. You can have more than single-shot firearms under the Second Amendment, obviously. Then we get our magazines. And once magazines fall under the textual definition of arms, which I think they clearly do, just like bullets do, guess what? The burden of proof shifts to the government to show through historical tradition that limitations on firearm capacity are long-standing traditional restrictions on our right to keep and bear arms, which the only conceivable history that touches fingers with, this is very important to understand, the only conceivable history that the Supreme Court has already done, remember the Supreme Court's already done this history on gun bans, the only conceivable test that the Supreme Court has said that touches fingers with any kind of a gun ban or arms ban, which would include magazine bans and ammunition bans, by the way, because they're all arms. The only possible legal test that would apply is, can the government demonstrate that historically, through historical analogs, the late 18th century, that dangerous and unusual arms were banned, and that there were specific historical analogs banning either, firearms or ammunition or multi-shot firearms or repeating firearms, of which they had, because remember, the Girandoni air rifle brought by Lewis and Clark on the expedition during the presidency of Thomas Jefferson, which is in the founding period, that held somewhere between 20 and 24 rounds. So founding fathers were well aware of firearms that held dozens of rounds. They were familiar with, repeating firearms and also multi-shot firearms and things of this nature. They were familiar with these things. So it wasn't like they never, and again, that's not even the standard because they weren't familiar with stun guns, but we know that stun guns are protected arms even though they were invented today. So the fact that semi-automatic firearms that include magazines are protected today and they're commonly owned, that's all you need to do on the text, since there's no history other than dangerous and unusual weapons, but the government can't prove that magazines, for example, are dangerous and unusual because they can't prove unusual. And why can't they prove that these are unusual? Because there's hundreds of millions of magazines that hold more than 10 rounds. So therefore, there's no way the government can ban magazines because, again, there's no way they can show that magazine bans, that magazines are somehow unusual because by definition they're not, since they're commonly owned by Americans to the tune of millions, if not tens of millions, if not hundreds of millions, all of which would be far more than the 200,000 figure in Caetano for the floor, maybe even below that. But certainly anything over 200,000 is clearly commonly possessed by Americans for the purposes of Second Amendment purposes. And because it's commonly possessed in the modern world, it cannot be dangerous and unusual. And because it cannot be dangerous and unusual under the law in the 18th century, it means, guess what? It cannot be banned. So magazines cannot be banned, no matter how many rounds there are, no matter what their capacity is. Ammunition cannot be banned, and all semi-automatic rifles, none of those can be banned either because, again, there's nothing dangerous and unusual about them because there's nothing unusual about them because they're commonly owned today, commonly possessed today for lawful purposes by Americans who choose these for self-defense and other lawful purposes, which is all that has to be shown by the plaintiffs in these cases. Okay, I hope you learned a little bit something about the Second Amendment today. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.